All right, we're going to try this again and see how far we make it before we're interrupted. Purportedly, I have bad signal according to Facebook, but I don't believe that to be the case. And with that said, we're going to get started without any further ado. Funny how when I'm not providing any instruction or talking about anything, my feed is not interrupted. The second I start talking about this stuff, I'm interrupted. Without any further ado, let's get started. It is instructive to summarize how citizenship, words of art, can be abused to enslave any people. Make the government into an unconstitutional monopoly in providing protection. This turns government into a mafia protection racket, Title 18 U.S.C. Chapter 95. Ensure that the government never prosecutes its own members for their racketeering crimes and instead uses the law only to selectively enforce against political dissidents or those who refuse their protection racket. This act of omission prompts anarchy by making the government not only the source of law, but above the law, not as a matter of law, but as a matter of invisible policy. Eliminate legal liability for the truthfulness of anything that any member of any branch other than the judiciary says verbally or in writing. This unleashes the Lucifer Effect, documented by psychologist Philip Zimbardo. You can find that on YouTube, the Lucifer Effect. This facilitates and promotes massive, rampant, unconstitutional, or illegal or injurious abuse by those in the legal profession and the government. You can also by the government abuse, unaccountable, and often anonymous government propaganda to make people falsely believe that civil statutes, all of which only pertain to the government, are the only remedy for anything. Everyone is a public officer called a citizen or resident who has to do anything and everything that any politician publishes in the employment agreement called the civil law. Any civil obligation any corrupt politician wants can lawfully attach to the status of citizen without compensation, because calling yourself a citizen is voluntary, and anything done to you that you volunteer for cannot form the basis for an injury. This doesn't violate the 13th Amendment because you volunteered. The citizen cannot complain because he has voluntarily submitted himself to such a form of government. He owes allegiance to the two departments, so to speak, and within their respective spheres must pay the penalties which each exact for disobedience to its laws. In return, he can demand protection from each within its own jurisdiction. United States versus Crenshaw, 92 U.S. 542, 1874, emphasis added. There is no common law. Common law is the only way to lawfully approach the government as a private human and equal rather than a public officer. Being a citizen under the civil statutes and employment agreement is a result of birth rather than civil domicile. This makes it impossible to unvolunteer because being born is not consensual, but selecting a domicile is consensual. Defining everyone in receipt of that protection as receiving a franchise benefit, in other words, turn justice into a franchise, gives this benefit the name privileges and immunities. Prosecute as thieves all those who refuse to receive the benefit or pay for the benefit. This happens all the time at tax trials. The government prosecution tells a jury full of tax consumers with a criminal financial conflict of interest in violation of Title 18 U.S.C. subsection 208 that you refuse to pay your fair share for receiving the benefits of living in this country, but are never even required to qualify or prove with evidence the actual value of such benefit. This turns the jury into an angry lynch mob, not unlike the mob that crucified Jesus, who are a weapon of mass destruction in the hands of a covetous prosecutor. It makes the defendant literally into a human sacrifice to the pagan god of government. Hypothetically refuse to prosecute government as a thief if they either collect payments for services that people don't want or don't use or collect more payment than the services delivered. Thus, the real party in receipt of a benefit is the government rather than the citizens. Implement a common law maximum that he who receives a benefit implicitly consents to all the obligations associated with the benefit. That way, if it is impossible to withdraw your implied consent to be protected or the obligation of the paying for that said protection, he who receives the benefit should also bear the disadvantage. He who derives a benefit from a thing ought to feel the disadvantage attending it. Bovier's Law Dictionary, Bovier's Maxims of Law, 1856. Call those in receipt of the civil statutory protection citizens and subjects, whether they want to be or not. Remove from legal language or legal discussion all those terms that describe people who are not citizens or subjects. These terms or subjects are called the third rail in politics or law. This will remove all tools people can use to escape the government slave legal plantation called the Civil Code. These people are called non-residents, transient foreigners, stateless, in transitu, transient, sojourner, civilly dead. Refuse to document or explain how they became subject or how to unvolunteer to become one. Even tell them it's voluntary, but refuse to offer a way to unvolunteer. In psychology, this approach is called crazy making. Crazy making, noun, a form of psychological attack on somebody by offering contradictory alternatives and criticizing or undermining the person for choosing either. Your dictionary, crazy making, downloaded 1/9/2018, sources yourdictionary.com. Crazy making. This obviously violates the First Amendment, but a government that is above the law doesn't care. Don't allow anyone but a judge to define or redefine these words, citizen or subject, so that the status cannot be challenged in court. Label the allegiance. National is someone with allegiance. That is the foundation of citizenship, to at least appear permanent and therefore irrevocable. Make it at least appear that the only way that one can cease to be a citizen is to surrender their nationality and become stateless everywhere on earth. Title 8 U.S.C. 1101, as used in this chapter 21, the term national means a person owing permanent allegiance to a state. Here is the definition of permanent that shows this description is happening. Title 8 U.S.C. 1101, definitions for the purpose of citizenship as used in this chapter 31. The term permanent means a relationship of continuing or lasting nature as distinguished from temporary, but a relationship may be permanent even though it is one that may be dissolved eventually at the instance either of the United States or of the individual in accordance with the law. Create confusion in the U.S. Supreme Court over what the origin of the government taxing power is and whether it derives from domicile or nationality. Former President Taft, the guy who got the 16th Amendment income tax amendment fraudulently ratified by Philander Knox, did this while he was serving as the Chief Justice of the U.S. Supreme Court. Or, to express it another way, the basis of the power to tax was not and cannot be made dependent upon the situs of the property in all cases, it being in or out of the United States, nor was not and cannot be made dependent upon the domicile of the citizen, that being in or out of the United States, but upon his relation as citizen to the United States and the relation of the latter to him as a citizen. The consequences of the relationship is that the native citizen who is taxed may have domicile, and the property from which his income is derived may have situs in a foreign country, and the tax be legal, the government having power to impose the tax. Cook versus Tate, 265 U.S. 47, 1924. Hope no one notices that. The common law has never been repealed and cannot be repealed because it is mandated in the United States Constitution, see the 7th Amendment. Furthermore, it's ratified in every state constitution. The common law must allow one to not accept a benefit. No one is obliged to accept a benefit against his consent, but if he does not dissent, he will be considered as assenting. He does not appear to have retained his consent if he have changed anything through the means of a party threatening. For more details on the fraudulent ratification of the 16th Amendment, see Great IRS Hoax. The term permanent really means temporary and requires your express and continuing consent, and especially in the context of permanent allegiance, that is the basis for nationality. Title 8 U.S.C. 1101 A31, the term permanent means a relationship of continuing or lasting nature as distinguished from temporary, but a relationship may be permanent even though it is one that may be dissolved eventually at the instance either of the United States or of the individual in accordance with the law. Use description, use deception, equivocation, and words of art to divorce domicile, which requires consent from the basis for being a citizen, and thus remove consent from the requirement to be a citizen. This has the effect of making citizen status appear compelled and involuntary. Do this by the following tactics. Presume that all of the four contexts for United States are equivalent. Presume that constitutional citizens and statutory citizens are equivalent under the federal law. They are not. A constitutional citizen is a non-resident non-person under federal law and not a citizen of the United States. Presume that nationality and domicile are equivalent. They are not. Use the word citizenship in place of nationality or domicile and refuse to disclose which of the two they mean in every context. Confuse the political constitutional meaning of the words with the civil statutory context. For instance, asking on government forms whether you are a political constitutional citizen and then falsely presuming that you are a statutory citizen under Title 8 U.S.C. subsection 1401. Confuse the words domicile and residence, or impute either to you without satisfying the burden of proving that you expressly consented to it and thereby illegally kidnapped your civil legal identity against your will. One can have only one domicile but many residents, and both require your consent. Add things or classes of things to the meaning of statutory geographic terms that do not expressly appear in their definitions in violation of the rules of statutory construction and interpretation. This allows everyone to be presumed to be a statutory citizen and franchisee. Refuse to allow the jury to read the definitions in the law and then give them a definition that is in conflict with the statutory definition. This substitutes the judge's will for what the law expressly says, and thereby substitutes public policy for the written law. Publish deceptive government publications that are in deliberate conflict with the statutes defined United States as, and then tell the public that they cannot rely on the publication. The IRS does this with all of their publications, and it is fraud. Label as frivolous anyone who exposes or challenges the above in court. What this really means is someone who refuses to join the state-sponsored religion that worships men and rulers and governments, and which has superior or supernatural power above that of any man, prevent challenges to being called frivolous by refusing to define the word, never having to prove with evidence that the claim being called frivolous is incorrect. The above tactics are documented. Protect the above scam by deceiving people litigating against the above abuse into falsely believing that sovereign immunity is a lawful way to prevent common law remedies against the above abuse. Sovereign immunity only applies to statutory citizens and residents under the civil law, not the common law. The above tactics essentially turn a republic into an oligarchy and make everyone a slave to the usually judicial oligarchy. That oligarchy is also called a critarchy. They make our legal system function just like a British monarchy for all intents and purposes. British subjects cannot abandon their civil status as subjects of the king or queen by changing their domicile, while under American jurisprudence, Americans can, but are deceived into believing that they can't. Now you know why judges don't like talking about the source of their unjust civil jurisdiction over you, which is domicile, or its relationship to how their civil statutes acquire the force of law against you. Definitions of key citizenship terms and context. Both the words alien and national in everyday usage convey a political status relative to some specific nation. Those who are nationals of the nation are members of the nation, and those who are aliens of the nation are not members of the nation. For any one specific nation, one is either a national or an alien of the nation. Therefore, to make any sense, the words alien and national must be used in the context which identifies the subject national that the person is either national or alien of. Within the country, United States, there are two nations. State of the Union, united under the Constitution and called the United States of America. People within the within this geographic are state citizens and are also called citizens of the United States in the Constitution and 14th Amendment. These same people within ordinary acts of Congress are non-resident, non-persons, federal territories and possessions subject to the exclusive jurisdiction of Congress. People in this geography are nationals of the United States as described in ordinary acts of Congress and Title 8 U.S.C. subsection 1101A22. The above distinctions have been recognized by the U.S. Supreme Court as follows. It is clear that Congress, as a legislative body, exercises two species of legislative power, the one limited as to its objects, but extending all over the Union. The other, an absolute exclusive legislative power over the District of Columbia, the preliminary inquiry in the case now before the court is, by virtue of which of these authorities was the law in question passed. Cohens versus Virginia, 19 U.S. 264, 6 Wheat, 265, 5 LED, 257, 1821. By the law, the several states and governments spread over our globe are considered as forming a society, not a nation. It has only been by a very few comprehensive minds, such as those of Elizabeth and the fourth Henry, that this last great idea has been contemplated. Thirdly, and chiefly, I shall examine the important question before us by the Constitution of the United States and the legitimate result of that valuable instrument. Chisholm versus Georgia, 2 Dallas U.S. 419 L1 LED 440 1793. The legal dictionary also recognizes these distinctions. Foreign state. Nations outside the United States term may also refer to another state, i.e. a sister state. The term foreign national or foreign nations should be construed to mean all nations and states other than that in which the action is brought, and hence one state of the Union is foreign to another in that sense. Black's Law Dictionary, 6th edition, page 648. Foreign laws. The laws of the foreign country or sister state. Black's Law Dictionary, 6th edition, page 647. Dual citizenship. Citizenship in two different countries. Status of citizens of the United States who reside within a state, i.e., person who are born or naturalized in the U.S. or citizens of the United States and the state wherein they reside. Black's Law Dictionary, 6th edition, page 498. American national. The term American national is defined by the Department of State in Title 8 U.S.C. subsection 1502 as follows. Title 8 U.S.C. subsection 1502, Certificate of Nationality issued by the Secretary of State for person not a naturalized citizen of the United States for use in proceedings of a foreign state. The Secretary of State is authorized to issue in his discretion and in accordance with rules and regulations prescribed by him a certificate of nationality for any person not a naturalized citizen of the United States who presents satisfactory evidence that he is an American national and that such certificate is needed for use in judicial or administrative proceedings in a foreign state. Such certificate shall be solely for use in the case for which it was issued and shall be transmitted by the Secretary of State through appropriate official channels to the judicial or administrative officers of the foreign state in which it is to be used. June 27, 1952, Chapter 477, Title 3, Chapter 4, Subsection 359, 66 Stat 273. The term not a naturalized citizen, as used in the above described, everyone in a federal territories and possessions. The courts have held that people in federal territories and possessions are naturalized citizens. Constitutionally, only those born or naturalized in the United States and subject to the jurisdiction thereof are citizens. Constitutional Amendment 14. The power to fix and determine the rules of naturalization is vested in the Congress. Constitution, Article 1, Section 8, Clause 4, since all persons born outside of this of the constitutional United States are foreigners, one, and not subject to the jurisdiction of the United States, the statutes such as subsection 1993 and Title 8 U.S.C.A. subsection 601, currently Title 8 U.S.C. subsection 1401, derive their validity from the naturalization power of Congress. Elk versus Wilkins, 1884, 112 U.S. 94, 101, 5 S period CT period 41, 28 LED 648, and Wong Kim Ark versus U.S. 1898, 169 U.S. 649, 702, 18 S period CT period 456, 42 LED 890. Persons in whom citizenship is vested by such statutes are naturalized citizens and not native-born citizens. Zimmer versus Atkinson. 10th Circuit Court, 1951, 191, F period 2D, 209, 211. Wong Kim Ark versus U.S. Supra, and Lil Shu versus Atkinson, 110 F Superior Court 50 in Indy, California, 1953. Footnotes. See Boyd versus State of Nebraska, Ex Rel Thayer, 1892, 143 U.S. 135, 12 S period CT period 375, 36 L period ED period 103 U.S. versus Harbaniku, 2 Circuit 1933, 62 F period 2D 795, 761. Consequently, the only human beings they can be referring to in Title 8 U.S.C. subsection 1502 are people from states of the Union mentioned in the Constitution as citizens. They could have simply said constitutional citizens instead of not a naturalized citizen, but they would have given away their biggest secret, which is that people born in the exclusive jurisdiction of states of the Union are not citizens of the United States within the meaning and scope of Title 8 of the U.S. Code, and that these people are not subject to the legislative jurisdiction of Congress unless abroad. State national. Throughout this document, when we use the phrase state national, we mean all the following: born or naturalized within a constitutional state of the Union, operating in an exclusively private capacity beyond the control of civil statutory laws of the national government, a national of the United States, a national of the United States of America, a national under Title 8 USC subsection 1101A21, owing allegiance to a legislatively but not constitutionally foreign state. The term state in Title 8 USC 1101A21 is a lowercase because it is legislatively foreign. A free inhabitant under the original Articles of Confederation, Section 4. An inhabitant under the law of nations. Not any of the following: a national of the United States under Title 18 USC subsection 1101A22, a statutory national and citizen of the United States at birth per Title 8 USC subsection 1401, a non-citizen national of the United States at birth per Title 8 USC subsection 1408, a person who, though not a citizen of the United States, owes permanent allegiance to the United States under Title 8 USC subsection 1101A22B, a citizen of the a U.S. non-citizen national under Title 8 USC subsection 1452, a citizen under Title 26 CFR subsection 1.1-1C, domicile on federal territory, physically present on federal territory, born on federal territory, representing an entity or office domiciled on federal territory, a civil statutory person under any acts of Congress, a civil statutory individual under any acts of Congress, no civil status under the laws of national government, such as person or individual domicile in the origin of all civil status, and without a domicile on federal territory, there can be no civil status under any act of Congress. Context for the word alien and national. United States, in its statutory geographical sense, for the purpose of citizenship, means federal territories and possessions and no part of any state of the Union. This is because Title 8 USC subsection 1101A36 and A38 and Title 8 CFR subsection 215.1F includes only federal territory and does not include any state of the Union. See the following for proof. Constitutional alien. This term, as used throughout our website, also means a foreign national born or naturalized in a foreign country who is not also a national of the United States. Statutory alien. This alien is defined in Title 8 USC subsection 1101A3 and Title 26 USC subsection 7701B1A to mean a foreign national born or naturalized in a foreign country who is not also a national of the United States. Always enclose in double quotes only the word alien for this class of people. Alien defined in Title 8 USC subsection 1101A3 as those people who are not nationals of the United States pursuant to Title 8 USC subsection 1101A22. Title 8 USC subsection 1101 definition A, as used in this chapter. 3, the term alien means any person not a citizen or national of the United States. National defined in Title 8 USC subsection 1101A21. This section of code provides a generic definition for national that does not specify a subject national and may be used to include people born in foreign countries. Therefore, for clarity, when describing yourself as a national, always include the name of the subject nation in your description. Always enclose in double quotes only the word national. Using this convention most Americans would describe themselves as a USA national pursuant to Title 8 U.S.C. subsection 1101A21. National of the United States, defined in Title 8 U.S.C. subsection 1101A22. This section of code defines a specific national and includes the name of the subject nation. Nationals of the United States pursuant to Title 8 U.S.C. subsection 1101A22 are those people born anywhere in the territorial United States, meaning a territory or a possession. Alien versus alien individual. The term alien, as defined in Title 8 U.S.C. subsection 1101A3, and alien individual, as defined in Title 26 CFR subsection 1.1441-1C3I, look very similar, but they are not synonymous. Alien, as used in Title 8 U.S.C. subsection 1101A3, are those people who are not nationals of the United States pursuant to Title 8 U.S.C. subsection 1101A22, or United States in a constitutional sense. Alien individuals are statutory individuals, Title 26 CFR subsection 1.1441-1C3, who are also statutory aliens pursuant to Title 8 U.S.C. subsection 1101A3, Title 26 CFR subsection 1.1441-1C3I. The term alien individual means an individual who is not a citizen or a national of the United States. See section 1.1-1C. All statutory individuals within the meaning of the Internal Revenue Code are public officers, employees, agencies, and instrumentalities operating in the respective capacity within the United States government under federal rules of civil procedure 17B. An alien individual pursuant to Title 26 CFR subsection 1.1441-1C3I is a public officer who is also an alien pursuant to Title 8 U.S.C. subsection 1101A3. This class, alien individual, is a subject of the class of aliens. All alien individuals are aliens, but not all aliens are alien individuals. Those taking the non-resident, non-person position documented herein are statutory non-resident, non-persons if exclusively private, or non-resident aliens if a public officer. They are not constitutional aliens. By constitutional aliens, we mean anyone born or naturalized outside of the constitutional state of the Union, not alien individuals, since they have resigned from their compelled Social Security trustee position. Therefore, if you describe yourself as an alien pursuant to Title 8 U.S.C. subsection 1101A3, it is important that you also emphasize that you are not an individual or alien individual pursuant to Title 26 CFR subsection 1.1441-1C3I, because not physically present in a statutory United States federal zone, you cannot have any civil status, including alien, without a physical or legal presence in the country to which you are alien in respect to. Historical evaluation of the term alien. In order to understand why state nationals are non-residents and even aliens in relation to federal territory and the income tax, we must go back in history and examine the relationship between the states of the Union after the Union was formed in 1776 and the statutory state territories who later became constitutional states. Each state that was formed after the Union of the initial 13 colonies began as statutory state territory and later was admitted to the Union as a constitutional state when its population got large enough. The transition from a territory to a constitutional state requires the citizens therein to transition from statutory citizen under Title 8 U.S.C. subsection 1401 to a constitutional citizen, or later in 1865. Citizens of the United States under the 14th Amendment, this was done through a process known as collective naturalization. There are two types of collective naturalization, statutory and constitutional. Statutory collective naturalization occurs when new territories are acquired but not but do not become constitutional states. Constitutional collectively naturalization under Article 1, Section 8, Clause 4, collective naturalization occurs after that territory is admitted to the Union. Alaska and Hawaii are the last two such territories to be the subject of constitutional collective naturalization when they join the Union. Individual rather than collective naturalization occurs under Title 8 U.S.C. subsection 1421. A statutory citizen from a territory or possession, such as Puerto Rico or Guam, is not equivalent to a constitutional citizen. In fact, those from federal territories are considered foreigners in relation to the states of the Union. Constitutionally, only those born or naturalized in the United States and subject to the jurisdiction thereof are citizens. Constitutional Amendment 14. The power to fix and determine the rules of naturalization is vested in the Congress, Article 1, Section 8, Clause 4. Constitution, Article 1, Section 8, Clause 4. Since all persons born outside of the constitutional United States are foreigners and not subject to the jurisdiction of the United States, the statutes such as subsection 1993 and Title 8 U.S.C. A subsection 1601, currently Title 8 U.S.C. subsection 1401, derive their validity from the naturalization power of Congress. Persons in whom citizenship is vested by such statutes are naturalized citizens and not native-born citizens. Notice the language. Since all persons born outside of the constitutional United States are foreigners, statutory citizens or statutory nationals born on federal territories are foreign and alien in relation to the constitutional state. The same thing applies to Indians living on the reservation. The above case doesn't say this, but the reverse is also true. Those born in a constitutional state are foreign and therefore alien in relation to the statutory state and federal territory. That's where the idea comes from that to call state nationals non-resident aliens under Title 26 U.S.C. subsection 7701B1B in relation to a tax that only applies on federal territories within the statutory but not constitutional United States under Title 26 U.S.C. subsection 7701A9 and A10, and Title 4 U.S.C. subsection 110D. So again, and Title 4 U.S.C. subsection 110D. This is the deep dark secret that the federal courts ruling on tax enforcement in State of the Union positively refused to discuss, because if they did, it would blow up the entire tax system. This subject is what Tip O'Neill called the third rails of politics. The third rail of politics deals with subjects that will either get you fired, reduce your pay, or impede your ability to get promoted. It applies to judges just as readily as politicians. Even though judges are not supposed to act in political capacity, it will be like pulling hen's teeth to get them to talk about this subject. Third rail of politics. The third rail of a nation's politics is a metaphor for any issue so controversial that it is charged and untouchable, to the extent that any politician or public official who dares to broach the subject will invariably suffer politically. It is most commonly used in North America, though commonly attributed to Tip O'Neill, Speaker of the United States House of Representatives during the Reagan presidency. It seems to have been coined by O'Neill, aide Kirk O'Donnell, in 1982 in reference to the Social Security. The metaphor comes from the high voltage third rail in some electric railway systems. Stepping on this usually results in electrocution, and the use of the term in politics relates to the risk of political death that a politician would face by tackling certain issues. Wikipedia, third rail of politics, downloaded 6/6/2018. Source would be https://wiki.wikipedia.org/wiki/third_of_rail_politics. Rick Schenkman. When did Social Security become the third rail of American politics? George Mason University retrieved 21st October 2014. William Safire, 8 February 2007 on language, third rail. The New York Times retrieved 21st October 2014. Below is an example provided that statutory nationals can be constitutional aliens where the petitioner was a Filipino citizen and a statutory national of the United States under Title 8 U.S.C. subsection 1101A22. Even then, they identify him as an alien. The petitioner urges finally that the requirement of entry is implicit in the 1931 Act, citing Fong Yu Ting versus United States 149 U.S. 698. He argues that the bounds of the power to deport aliens are circumscribed by bounds of the power to exclude them, and that the power to exclude extends only to foreigners and does not embrace Filipinos admitted from the island when they were a territory of the United States. It is true that Filipinos were not excludable from the country under any general statute relating to the exclusion of aliens. See Gonzalez versus William, 192 U.S. 1, 12 through 13. Toyota versus United States, 268 U.S. 402, 411. But the fallacy in the petitioner's argument is the erroneous assumption that Congress was without power to legislate the exclusion of Filipinos in the same manner as foreigners. This court has held that the power to acquire territory by treaty implies not only the power to govern such territory, but to prescribe upon what terms the United States will receive its inhabitants and what their status shall be. Downs versus Bidwell, 182 U.S. 244, 279. Congress not only had, but exercised the power to exclude Filipino in the provisions of subsection 8A1 of the Independence Act, which for the period from 1934 to 1946 provided for the purposes of Immigration Act of 1917, the Immigration Act of 1924, except sections 13C. This section and all other laws of the United States relating to the immigration exclusion or impulsion of alien citizens of the Philippine Islands who are not citizens of the United States shall be considered as if they were aliens. For such purposes, the Philippine Islands shall be considered as a separate country and shall have for each fiscal year a quota of 50. 48 Stat 462, 48 USC 1934 ED, subsection 1238. The 1931 Act plainly covers the situation of the petitioner, who was an alien and who was convicted of a federal narcotics offense. CF United States X-Rail Inchenslaba versus Shagranesi, 338 U.S. 521, were therefore concluded that the petitioner was deportable as an alien under that act. The judgment is affirmed. Mr. Justice Douglas dissenting. No matter how the case is viewed, in 1931, Act is applicable only to aliens who had made an entry in this country. The Filipino came to the United States in 1930, and he has never left here. If the spirit of the 1931 Act is to be observed, he should not be lumped with all other aliens who made an entry. The Filipino alien who came here while he was a national stands in a class by himself and should remain there until and unless Congress extends these harsh deportation measures to his class. Rabang versus Boyd, 353 U.S. 427, 1957 is the source. With that, we'll come back a little bit later and touch base on more of this document that I feel is imperative for people to learn, gather, and acquire the knowledge. I do these videos again to help myself because I'm a visual audio learner. So to read it, to hear it, to write it, I'll remember it. I'll put it in my spank bank and I'll have it for later dates. For those of you looking for good study habits, that's how I do it. People often ask, how do you retain so much knowledge? I read it, I write it, I speak it, and I transcribe it if need be into my own words to better articulate for myself. And I would encourage everybody to do the same so that when you're put on the spot and questioned by rogue agents and agency trying to force you into a certain status so they can impose their will and their whim upon you, you can stand vigilantly on your square and defend your unalienable rights with vigor, great vigor, because that's what it takes. Freedom isn't free. It never has been free. And this goes for every nation. We all have unalienable rights. The right to be left alone, the right to the pursuit of happiness. Everybody has those rights. They're natural, unalienable rights. So we'll come back and we'll get back into this document some more. I have some other information that I want to disseminate upon you guys a little later down the road here to help you understand. But a lot of people were struggling with citizenship, nationality, and stuff, and I hope this answered your questions. Thanks for joining me, and thanks for your support.